Welcome to our Wednesday webinar. Unfortunately, today there's going to be a lot of changes, so apologies for that. So our host and funny man, Chris is unfortunately feeling ill, so he's not going to be around today. So probably a lot less jokes, but I'll try to throw some in wherever I can. And Cilna isn't available today either. So we've got a special guest, Nick Brodie from SSLR Incorporated, stepping in for Cilna. And Nick, say hi, introduce yourself. Tell us a little bit about yourself.
Perfect. Thanks, Bruno. As you say, Cilna's taken some well-deserved leave. Unfortunately, not as pretty as Cilna, but I'll try my best to, contribute. And I'll throw in a joke there or two if I can. Thank you. As I say, my name is Nick Brodie. I am one of the other directors at SSLR Incorporated. I'm in fact the head of our commercial department, and I do retail industrial work as well. I've been a director there for, I don't know, going on sort of 7 years now. So I've got a little bit of experience in the business.
Sure, that's commitment.
Yeah.
No. Cool. Well, that's brilliant. So off the back of that, it's exactly why today we wanted to focus the episode around evictions, seeing as that is Nick's strength, and maybe drawing some comparisons or distinctions between residential evictions and commercial evictions. Why this is important is we have a range of viewers that might commonly ask these questions on, but hold on, wait. I know that if that guy does an eviction at that one particular place, it's a lot quicker. It's just a kind of an understanding on the basis on why evictions are done in a particular way, why a person's home is treated and given possibly, I mean, one would say more rights than a commercial eviction, for example, what the processes look like. And then we'll probably roll into a section just discussing some of the experiences, some of the common things that we've seen in commercial evictions, some of the things that we see in commercial evictions that we don't in residential and vice versa. So we'll keep the comparison going. So Nick, do you want to maybe get started with like your the big differences?
Yeah, so I think that the most material difference between your residentials and your commercials is obviously the application of PI to the particular eviction. So we know PI well. Obviously, the minute you're doing a residential eviction, PI is the fundamental legislation that is governing how that eviction is done, how you need to present that eviction to the court at the end of the day, and what averments you need to actually be successful in your eviction when doing a residential eviction. Now, the fundamental difference between the residential and the commercial eviction is that the application of PI doesn't happen where you have a commercial eviction, okay? So that whole legislation doesn't come into play. You don't have to make the same averments as you would in your residential eviction, okay? And the most important thing when it comes to your commercial eviction is that there is no governing legislation as it stands right now in respect of commercial evictions, okay? There's no overriding provisions, nothing in legislation that says this is how a commercial eviction needs to be done. So that being said, the most fundamental document that comes into a commercial eviction is actually the lease agreement itself, okay? Nothing overrides that particular provision, and this is why it's so important to make sure that your lease agreement, I mean, both in respect of residential, but more importantly in respect of commercial, is strong, okay? And it protects your rights fundamentally, because at the end of the day, when you bring a commercial eviction, the eviction is going to be based on the document that is concluded between you and the tenant entirely, okay? Obviously, same sort of thing applies when it comes to commercial evictions, in that you don't have to have a written document for a valid lease agreement to be in place, and it is perfectly valid to have a tacit or implied lease agreement with your tenants in the circumstances. And there are ways of dealing with an eviction if there is not a written document in place. But obviously, the suggestion from us is always have a strong document in place. If you are the landlord, make sure that's signed in place so that if there is a breach of the agreements in some way, you've got something to refer to immediately, and something that is clear, so that you can proceed with the eviction without too many problems from the start.
Yeah, that's actually a really nice way of putting it and summarizing it. What I found from my experience in my commercial eviction divisional department is because we don't have to worry about the application of pi, your time periods are substantially different. I mean, it's almost intuitive that it is. So what you find is this pi allows for certain considerations to be made when it comes to residential eviction. So the courts want to weigh up the rights of a person's right to housing. Now, a person's right to conduct trade is very different to a person's right to housing. Right to housing is a basic right, it's fundamental. Whereas a right to conduct trade can still occur without a person necessarily having leased premises. So yes, to a certain degree, it is still an infringement, but it's, you'd almost say it's a more justifiable infringement than simply kicking somebody out of their house without any due consideration. So pi was created for this purpose, in order to kind of govern how the Constitution was going to deal with removing people from their residential premises, and whether it's justifiable, whether they have a place to move into. Same thing doesn't apply to commercial evictions, which makes them a lot faster. So the one interesting conversation, I suppose we can have it now, we can have it, if it's a long one, we can have it afterwards, but so the application of whether it's a commercial eviction or residential eviction isn't necessarily based on the nature of the property, right? Or it's based on the use of the property, what those specific occupiers are using the property for. So if a person is sleeping on your commercial property, you can't try kick him out as a business, because it's not a business.
Absolutely, and that's a fundamental point that I have this conversation with landlords all the time, where they come and they say, "Look, I've got this commercial property. I need to do an eviction on the particular property. If there is someone staying inside that premises, okay." Pi is a very wide piece of legislation, and it covers almost everything if there is a person who is residing in that premises, even for temporary occupation. So I often have landlords who come to me, they say, "I've got this commercial piece of property, I need to do a commercial eviction." And it is so important for you to let your attorney know, if you are doing an eviction, whether there is someone residing in that property. Because if there is someone residing in that property, our law considers that to be a residential eviction, irrespective of whether the intended use of that property was supposed to be commercial, and irrespective of whether the property is in fact zoned for a commercial or an industrial use. Our law will consider that you have to do a residential eviction, and you've got to bring those averments that pi requires to the attention of the court in order to do the eviction properly. And I say it's fundamental. I have seen cases which are heartbreak cases where we will do a commercial eviction, we will get all the way to the end, we're about to get an order, and someone will let the judge know on the day that there is in fact someone who is going to be rendered homeless as a result of the eviction order. And I can guarantee you, our judges will dismiss the matter immediately, because you have not followed the provisions of pi in order to acquire your eviction order. And you will have to start your process all the way from the beginning, follow out a residential eviction process, and follow the provisions of pi. So it is fundamental, if you are proceeding with an eviction and it is a commercial premises, if there is someone living there, you do let your attorney know, so that they can follow the appropriate process. And there are often cases which I receive where, even if you don't know whether it's going to be a commercial or going to be a residential eviction, always follow the residential route, just in case. It is far safer to go down the residential route, just in case there's someone living there, and you don't have that risk of being knocked back to the start of the process, which is, I mean, it's a devastating thing to see if it does happen.
Yeah, it's one of those when in doubt, it's not wrong to bring the application. And I suppose people don't know this. So the applications are similar to a certain degree. I mean, you approach the court in a very similar fashion. Pi just adds an extra layer or extra hurdle rather that us as applicants need to jump over. So if you go automatically or voluntarily and add that layer, a court's not going to say that you did something wrong because you actually just made your life harder. So if you happen to be wrong and it turns out it's commercial, yes, you waste the time, but you did the right thing. If it turns out it's residential, you don't need to start from the beginning. So it's a bonus. So when in doubt, rather do it the long way than regret it like 6 months or 9 months down the line and have to start again from the beginning.
Absolutely. It's so much better. Rather tick off those boxes, and your attorney will have a way with dealing, because in those circumstances, you might not know exactly what's going on the particular property. And we do have landlords who, unfortunately, with really delinquent tenants, they may have prevented the landlord from going into there for a certain period of time, even commercial properties. So you don't know. And in those circumstances, just go for the safety, make the extra averments, to the court, and get your eviction that way.